5 seconds. Start. From the provisions of the Consumer Protection Act, the position is clear that the consumer disputes redressal agencies such as district forums, state commissions, and the National Commission are vested with powers of adjudication of all types of consumer disputes. Full stop. No exception is made in case of consumer disputes in which the allegations made in the complaint regarding deficiency of service causing damage to or loss of the goods are contested. Full stop. Indeed, finality is attached to the orders of the redressal agencies and provision is made for execution and implementation of the orders passed by them, treating such orders as decree of the court. Full stop. It is relevant to state here that on perusal of the provisions of the Act, it is clear that the scheme of the statute is to provide steps of redressal, forums for attending to the grievances of consumers regarding deficiency in service promptly and give finality to the orders passed by the agencies. Full stop. Therefore, it is difficult to accept the contention that the dispute redressal agencies provided in the Consumer Protection Act are not forums which have jurisdiction to entertain the complaints in which claims for loss or damage to goods and trust to a carrier for transportation is seriously disputed. Full stop. It is true that the Act is protective legislative to make available inexpensive and expeditious summary remedy. Full stop. There must be a finding that the respondent was responsible for the deficiency in service, the consequence of which would be that the appellant had incurred the liability for loss or damages suffered by the consumer due to deficiency in service thereof. Full stop. When the parties have contracted and limited their liabilities, the question arises whether the State Commission or the National Commission under the Act could give relief for damages in excess of the limits prescribed under the contract. Full stop. It is true that in an appropriate case, the tribunal, without going upon acute disputed question of facts, may decide the validity of the terms of the contract based upon the fact situation and may grant remedy. Full stop. But each case depends upon its own facts. In an appropriate case where there is an acute dispute of facts, necessarily the tribunal has to refer the parties to original civil court established under the Civil Procedure Code or appropriate state law to have the claims decided between the parties. Full stop. But when there is a specific term in the contract, the parties